introduce yourselves.
Sure. Good morning. Thank you, Mr. Chair. Greg Bloom, the designee of the Commissioner of Public Lands. Thank you.
Good morning, Dr. William Ampoma, designee of the Energy Secretary. Thank you.
Excuse me, Mr. Rosados, I don't think your mic is on. Yeah, is it?
Hello?
Testing. Should we start it over? Yeah, we'll just start it over since I wasn't heard at the first round. So again, I'm Gerasimus Rosados. I am the acting director for the Oil Conservation Division. I'm also the acting chair for the Oil Conservation Commission. We'll just do roll call real quickly one more time. Commissioners, if you can introduce yourselves.
Yes. Thank you, Mr. Chair. Greg Bloom, designee of the Commissioner of Public Lands.
Dr. William Ampoma, designee of the Energy Secretary.
Excellent. Thank you. Appreciate it. As stated, this was the special meeting for the Oil Conservation Commission. Today is February 3rd, 2025. Our first item that we need to do is approve our agenda for February 3rd, 2025. Can I get a motion to approve?
I move to approve.
I second.
Excellent. Thank you. So our agenda is approved for today. We'll move on to our next set, which are our pending cases. First case is the consolidated cases by Goodnight Midstream and Empire, New Mexico. And it's as follows. It's case numbers 24123, 23614 through 17, 23775, and 24018 through 20 and 24025. Is everybody present from Goodnight, Empire, and from the OCD?
Yes, Director. Yes.
Good morning, Mr. Director. Adam Rankin with Good.
Things are acting weird, Sheila. There's another one that's not working. There we go. It worked.
Thank you. Dana Hardy on behalf of Empire.
Ernest Alpady on behalf of Empire.
Sharon Shaheen on behalf of Empire.
Excellent. Thank you. So before we started, I know, Mr. Rubin, you wanted to step in. Mr. Daniel Rubin is on our online platform right now. So, Mr. Rubin, I'll transfer it over to you.
Thank you, Mr. Chair, and good morning, everyone. I'm appearing virtually because I am probably contagious in some capacity at this point, based on how I'm feeling. So the reason I asked that this item be put on the agenda, there was a motion by the Oil Conservation Division to compel the testimony of Dr. Lindsay, who will be a testifying expert by Empire. And while there are other pre-hearing motions that we will resolve the first day of the hearing, due to the exigent nature of this motion, it was proper to hear it today because what Empire has done is asserted privileges that would prevent OCD and perhaps Goodnight from discovering the facts and opinions held by their testifying expert, Dr. Lindsay. And so to wait till the first day would be one of those instances of justice delayed is justice denied. So I think it's pretty clear we are guided by Rule 26 of the Rules of Civil Procedure governing discovery. We use that as a guide. In fact, I reviewed the briefing of both OCD and Empire in response as filed by Mr. Padilla. And so at the deposition, I think the first objection Mr. Padilla made was that this is an attorney-client privilege communications between him and Dr. Lindsay, or his firm and Dr. Lindsay. I don't see any grounds for that. There was nothing in Mr. Padilla's response that indicated a contract, or nor did he even argue that point. It's hard to fathom how he would be, at least in this case, hired by Dr. Lindsay as his attorney. So I think, so what's left is, did the questions asked by OCD seek some privileged work product? Generally speaking, under Rule 26B, 6A and B, the facts and opinions held by testifying experts are completely open to discovery. That's a bedrock provision of Rule 26. That's how it works. Now, of course, under 26B5, there's trial preparation materials and, in fact, attorney work product that is not discoverable generally, except with some hardship. And even there, attorney work product is generally not discoverable. However, there is nothing I see in the case law that says that once whatever's said to an expert by an attorney or otherwise that becomes part of that attorney, that testifying expert's facts and opinions, that's part of Rule 26B, A, and B. That is what is discoverable, and that is what it appears OCD was seeking here. What are the facts and opinions held by Dr. Lindsay? You cannot insulate your expert's facts and opinions from discovery by asserting that it was stuff that based on communications with the attorney. And so, of course, lawyers need to be careful in communicating with their experts. The holding that Mr. Padilla cited, the Pacific Gold Corp case, which does not stand for a contrary position to what I've just said. There was no issue in that case of a testifying expert's facts and opinions held as being asserted as work product. So, to the extent that Dr. Lindsay had facts and opinions as of the date of that deposition, he should have been testifying to them in that deposition. I do want to, I guess the final point is we do have a scheduling order, and the rebuttal testimony reports are due February 10th, coming up in about a week. The deposition occurred in mid-January, the 17th. So if Dr. Lindsay at that point of the deposition didn't have his facts and opinions and everything was in draft form, he probably should not have been produced. I know that there's sort of a common understanding, if I'm producing my expert, it's because they're ready to be deposed. So if at that deposition, Dr. Lindsay had yet to form his opinions and have any facts to base it on, maybe it would have been a proper objection, but you still have to parse that out under 26B7A. What portions are facts and opinions held versus the trial preparation or work product. So my conclusion is that it's that Dr. Lindsay, by being noted on, I believe it was January 6th as a rebuttal expert, and being produced for deposition, had discoverable facts and opinions. And you cannot, again, shield those by saying that it's work product. So my recommendation to the commission is, so that we can have fair and open discovery to allow preparation before the hearing, the motion of OCD I recommend be granted with the further direction that Empire produce Dr. Lindsay in a timely manner, with further instruction that his facts and opinions held in this case that he intends to testify to are subject to discovery. So with that, I stand for questions from the commission. I don't see the need I didn't see the need for oral argument on this. It seems like the parties pretty much covered everything in their briefing, which was excellent as usual. So are there any questions from my clients?
Commissioners, do you have any questions?
Not from my side.
Not at this time, Mr. Chair.
I don't have any questions either. So at this point, Mr. Rubin, do I put a motion to see who approves it?
Yes, let me state, I would ask for a motion by the commission to grant the motion of OCD and to approve and to require Empire to produce Dr. Lindsay at a deposition in a timely manner. The further instruction that his facts and opinions held are subject to discovery.
So before we go to that, the OCD is wanting to state something.
So one of the problems we've got here is our procedural order was built in such a way that if this motion were to get granted today, that's going to result in a reconvened motion post rebuttal disclosure. And those would be the final opinions. In district court, that would usually happen way ahead of a hearing really with the rebuttal opinions, those would have been consolidated. So a deposition taken of an expert would have covered probably everything there would be to that opinion in totality. I appreciate Mr. Rubin's comments on this. I do think there probably should be a record, or the party should be allowed to make a record on this issue because it involves privilege. And if this does end up in an appeal, which I think not necessarily on these grounds, but there's a virtual certainty that's the case with these cases. I think there should be a record made in order to preserve those arguments for the Court of Appeals or the reviewing body. So in sum on this, I think one, there is an element, and I think it's important, candor towards the tribunal, that there's a level of mootness here because there just isn't going to be enough time to get a deposition done before the disclosure. I can certainly say, I'm not going to be able to get this done by Friday at 5. I'm not going to encourage anyone to be dragged into a deposition over a weekend, especially with a deadline Monday and a big one at that. So there's a level of mootness in this. On the other hand, I do think the parties should make that record so that way it's preserved, arguments made, authorities, et cetera.
Okay. I kind of agree with that. I think we should have a record here as well. So I will open it up. Go, Commissioner Bloom. Did you have something first?
No.
No?
No.
Okay. So I actually will open it up. I don't this could actually drag on for hours just on this very topic. So for the sake of expediency, let's keep the comments and arguments on the more concise aspect, please, so that we can all have a fair share and a fair say. So I am going to start with you, Mr. Moander. Was there anything else that you wanted to add?
I just had a few thoughts on, and I will express these with brevity, covering Empire's response. I mean, recognizing Mr. Rubin's spoken on this. The citation rule, I do agree that Rule 26 ultimately would govern this issue. And in its advisory capacity, again, there's nothing that requires the OCC to follow with any degree of stringency Rule 26. The citation of the United Nuclear case is interesting because it involves non-party expert witnesses and the common interest doctrine, which is not at all in play in this case. And there was a lot of nuance in the facts that distinguish it from a run-of-the-mill expert witness issue. So there is something to distinguish it there. OCD relied on it as well, but it was for a general provision of law about discovery that the court had reiterated and was part of its analysis. The reliance on the federal rules of civil procedure, they don't apply to state and state administrative matters unless there's a jurisdictional element that would necessitate their application, which isn't the case here. There's no federal question. There's no federal statute that's at the crux of the dispute between Goodnight and Empire. Also, there was a citation to In Re Sendent. It's a case that concerns the Rule 26 of the federal rules, but those are not the same. I was not able to provide a copy of each to the commission. The federal Rule 26 is a beast. It has mandatory report requirements, mandatory disclosures. They're usually on what state practitioners see as an abbreviated timeline, mandated pretrial disclosures. The other two cases that were cited basically said if the federal rule is an analog of the state rule, that state courts can look to federal guidance as to how to interpret the state rule of civil procedure. In the Romero case, it did concern Romero. That case concerned Rule 23, 1-023, not 1-026, a very separate rule that does seem to align more with the federal one. And that applies also to the Romero case, again, Rule 23, not 26. And then finally, Empire didn't argue against any of the evidentiary discussion that OCD presented, specifically rules 501 and 503. OCD construes that as an acquiescence to that argument, or the arguments made in support thereof. And that's all I have to say. Thank you, commissioners.
Excellent. Thank you. I will now turn over to Empire, who will be talking. Mr. Padilla.
May it please the commission. As Mr. Moander points out, I've been at this business 50 years. I've done federal cases, I've done state cases, and I expect discovery disputes to be handled in those cases. The last case I had was a case against Delta Airlines, and we had a discovery dispute in the federal court. I don't expect that type of scrutiny in an administrative proceeding. Matter of fact, this case has brought new items that have never been typically argued or have become issues in before the Oil Conservation Commission or the division. We have a number of depositions already. I've never really had depositions other than unavailability of witnesses from time to time. We've had a motion for summary judgment that I'm working on right now. I mean, I've never heard of a motion for summary judgment before the Oil Conservation Commission. Let me put it that way. So there are a whole bunch of things. But over the years, when attorney communications between expert witnesses or consultants come up, there's going to be a discovery dispute. In this case, the question was asked, have you discussed this with your attorneys, not necessarily your attorneys? And the answer was, yes, I talked to Sharon and Ernie yesterday. At that point, we had not formulated a response or rebuttal testimony at all. There had been some discussion, but not with Dr. Lindsay. And Dr. Lindsay had some ideas, but those were directed strictly to fracture studies. So when you ask, and again, over the years, communications for lawyers with lawyers, it's just not, you don't go into that unless there's fraud or some kind of information. In this case, we've been very careful in depositions where one of the first questions are, who'd you meet with? And in the last deposition I did you meet with Mr. Rankin yesterday? And the answer was yes. If Mr. Rankin was there, I'm not going to go into what the discussions were. And that's exactly what we have in this case. Irrespective of the argument that Mr. Rubin makes or his conclusion, or the argument that Mr. Moander makes. I mean, we're not in a federal court. We're not in the district court. Application of evidentiary rules, Rule 26, and on top of that, Mr. Moander, in his discussion at the end, states that I've been in practice 50 years, and I don't know whether that means I've lost my marbles or I should be sanctioned because he suggests that as well. I don't know the basis. Maybe he was trying to find out if I paid my bar dues, but the point is that by bringing that up, before the commission is just almost irrelevant. I mean, our rebuttal testimony, and I can represent today that the rebuttal testimony of Mr. Lindsay will not affect anything that the Oil Conservation or Division's case is about. It's a fracture study showing that there may be communication between the Grayburg and the San Andres. To the extent that this is an overwhelming deal, that the division needs to find out exactly what Dr. Lindsay is going to say in his rebuttal testimony, and it'll not affect I can represent that. It's not going to affect the Oil Conservation Division. So it's a big, the division has made a big case out of really nothing. I suppose we have never provided drafts until after the final paper is submitted. And that's been the practice in this case, even though this case is extraordinarily different from a lot of other cases. But to apply Rule 26 the way Mr. Rubin analyzes is improper for an administrative proceeding. The test here is going to be whether each party has substantial evidence to support a conclusion that the commission may make at the end. Applying evidentiary rules, I think is improper. I think, but when the question is asked, what did you discuss with the lawyers? I think that is not proper. So I take a different view on the reason for my objection. My objection, I was immediately alerted to an objection once the question of what was the discussion between you and Sharon and Ernie, essentially. And that was the day before when no draft was available. This issue, I think, is going to be moot once we submit the rebuttal testimony on February 10th. Now, in anticipation of that, if we're prepared to submit some kind of a draft before then, I would suggest that Empire do it. But otherwise, it hasn't been the practice. Thank you.
Thank you, Mr. Padilla. Mr. Rankin.
Thank you. I don't have anything really to add to this discussion. Although I'll let Mr. Moander address it. I do have two items that I would like to raise. They're not on the agenda today, but they are pre-hearing nature. And I think it's important. I want to raise them for the commission's awareness. I do think it'd be helpful if we could possibly get determination on those two issues in advance. And I'd like to just comment on those so I can explain why I think it's important for the commission to evaluate those before the 20th, if possible.
So let's wrap up this one and then this issue, and then we can always come up to that. So you have nothing else to add for this particular issue? Okay, thank you. Commissioners, any questions that you may have?
A quick one. So, Mr. Padilla, you were saying that Dr. Lindsay's testimony will not really impact anything, but he talked about fractures. So I don't know the magnitude of, let's say, the discussion, but if you talk about fractures in the San Andres probably impacting, let's say, top layers, that is relevant to the discussion, from my opinion. But I don't know the significant, I don't know all the details with regards to, let's say, what Dr. Lindsay can bring to the table. But once you start talking about fractures, that just prompts my attention to the fact that if there are some communication through fractures within the San Andres and, let's say, the upper layers, that is a matter that is of a concern. I know that during the pre-hearing periods in the past, OCD talked about the fact that they have concerns within the injection that is actually going on in the San Andreas. So once you start talking about fractures, I want to hear that. Thank you.
Mr. Ampara, Dr. Lindsay has already testified in his first testimony that's before the commission already that there may be contamination into the goat seep from injection of produced waters into the San Andres. As far as, and he has already talked about fractures occurring in some of the well bores, especially the 679 well, where there was a fracture study. I think the rebuttal testimony is going to go against, or is going to rebut Mr. Preston McGuire's testimony in his deposition and in his paper. So that fracture study is already before the commission. And the rebuttal testimony is going to be strictly against Mr. Preston's testimony.
So she already offered testimony to the commission.
It's already before the commission.
Okay, but she will not be here. He will not be here to respond to, let's say, any questions that we may have.
So I'm going to interrupt. I think we're going a little outside of the scope of this. I apologize, Commissioner Dr. Mpoma. We're not really talking about what Dr. Lindsay is going to be testifying. The question here is, did the OCD have the proper opportunity to be able to depose get a deposition from Dr. Lindsay? Sorry, no disrespect to the doctor. And was it following rules? And that's, I think, what our question is right now. And so I don't mean to interrupt. I don't want to go further into this particular case without being in the case. So let's not go on to that. I think we need to play it on the safe side on this instance. Before any questions, though, Commissioner Mpoma, for this particular issue, do you have any other questions for this particular issue? I want to make sure we capture it.
No, I'm okay.
Okay. Commissioner Bloom.
Mr. Padilla, thank you. Just to clarify, are you concerned about Dr. Lindsay being called back to the deposition, or specifically, are you concerned about him being asked about a document that is still in draft form, an unfinished work product?
Well, I think it's pretty final now. So, but I haven't been handling that aspect of the. My understanding is that it's pretty final. I know that drafts were, but at the time that I've made the objection, we had only the day before. All that was impressions of what we had and thinking process of opinions. I think those are protected without more. But we're not concerned about ultimately turning in the rebuttal testimony. We have to do that if we're going to submit rebuttal testimony, and I can represent that there will be rebuttal testimony against what Preston McGuire said in his deposition.
Ms. Hardy, did you have something to add to that?
Well, I just wanted to sort of clarify that I think there was some misunderstanding that the questions that were objected to just related to Dr. Lindsay's rebuttal opinions, which were still in development at the time of the deposition. We will submit them in final form with the other rebuttal testimony on February 10th. So that was the sole basis of the objection. Dr. Lindsay was deposed for a full day about all of his opinions in the case, and he will testify at the hearing. But the objection was limited just to his rebuttal, which was still in development. And since that will be filed on Monday, I think that's why everyone agrees it's really a moot issue at this point, that he didn't have answers, or he didn't answer questions at his deposition about the opinions for rebuttal that were being developed. I just wanted to make sure everyone was on the same page because I think there was some confusion.
I think we are on the same page. I think we understand. The question, though, in the end is, did the OCD have the proper opportunity to do a deposition to Dr. Lindsay? I think that's the question. There was the objection from Mr. Padilla. There is the concern raised from the OCD. And now it falls on our plate to try to figure out, did the OCD have the appropriate amount of information to be able to do a proper deposition of Dr. Lindsay? Commissioner Bloom.
Yes. So, and I thank you for clarifying that, Ms. Hardy. And Mr. Moander, you did speak to the question of, or the point of, this may be moot at this point. I mean, can this be dropped, or are you looking for a finding here from the commission that supports this for something later on?
Thank you, Commissioner Bloom. I mean, the problem is if I get the relief requested, it's probably at this point, it won't be helpful. It won't advance any deeper understanding on the part of OCD. And just to be clear on this is an issue of timing. It's not that the motion lacks, in OCD's view, inherent value. It's that the relief sought will, in essence, be given in the form of the final opinion. I was looking for what had been developed to date on that, because I'm not convinced that, generally speaking, you're not going to have rebuttal filed in more traditional litigation environments. And so you would be able to depose an expert once, and it's a one and done process. And then if there's a discovery dispute, you have time to take it back to a court and hash it out, get an order, reconvene a depo if you need to, whatever the case would be there. In this instance, even if I get that relief, I'm not sure it's going to be helpful, but I did need to make a record of this issue because, again, and this kind of brings me back to another point that I think is important. This case will eventually end up in an appellate posture, and these are things that I've been trained to preserve issues for the record for appellate review, and that's what's going on here. So if the relief I ask for is granted, I would see it as, I'm not willing to totally concede my motion on those grounds, which I'm doing to some extent here. I'm going to get these final opinions. That's what's going to be heard by the commission. That's what I would expect Goodnight to be attacking. And if I need to, I would be attacking that in the hearing. And that'll be the axle on which Dr. Lindsay turns. So a reconvened deposition won't get me anything. I wanted to get, let me give some context to this. So OCD took a position that no one issued discovery to OCD. No one seemed to know what it was. If I'm not asked, I'm not giving, is a general rule. So there was a bit of a surprise across the board as to what OCD's position is. OCD is in a position now when rebuttals filed. That'll be the very first time they're going to see opinions that may be contrary to OCD's position, which puts us in a disadvantage. I mean, that's a disadvantage. That's built into the structure. It is what it is. OCD is not complaining about that, to be sure. And so there was an interest in figuring out what could I learn as soon as possible before rebuttal to help my witnesses prepare theirs. That benefit will evaporate as of Monday for OCD. And like I said, there's just no realistic way, even if you ordered us to do it, it would be heaven and earth moving to get attorneys and a witness and a deposition within the next 4 days. And I'm not convinced that juice may not be worth the squeeze. I do want to make a clarifying point. There was no implication, this is a personal angle, no implication that Mr. Padilla is somehow deteriorating or in any way failing in his duties. That was an emphasis point that Mr. Padilla's got more than twice the experience that I do practicing as a licensed attorney. So a rhetorical device and not intended to imply any incompetence or anything on his part. I do want to note that there's not going to be any rebuttal discovery, but he made an interesting point about not asking about legal communications and depositions. In my experience, in multiple sectors of litigation, that question gets asked pretty much every time about expert witnesses. In fact, I'd argue if you don't ask it, you might not be pushing the envelope far enough. There'll always be a discussion about it. Most of us know what we're looking for, which is what are these foundational elements? I've had cases where I've been forced to turn over reams of emails that I've wrote to experts and had them returned to me. I think it's much more common. But one last point, touching on the appellate posture position, the entity that will do the appellate review is going to be reviewing this case through the state rules of civil procedure, not applying them strictly, but that will be the lens through which they look at it. I think it's a better practice to center on state rules over the federal rules. They're very different. And the appellate courts look at the state rules of civil procedure.
All right, thank you, Mr. Moender. No further questions, Mr. Chair.
So
Mr. Chair?
I'd like to ask just one question, Mr. Rubin, if I may. Just give me 1 second. So, Mr. Moender, I guess if reprieve is granted in this instance, if I understood you correctly, this is just for preservation in the appellate if and when this goes to appeals. Is that what I'm understanding?
Chair, that is correct with a caveat. I do think the merit has motion, but the timing is such that the relief won't accomplish much, if anything. I mean, the timing has made it somewhat useless, but I did want to make that record for preservation purposes as well.
Okay, thank you. Mr. Rubin.
Yes, thank you, Mr. Chair, members of the commission. I appreciate the colloquium, and I haven't heard anything that departs or changes my analysis. I had presumed that there would be another attempt at a deposition, perhaps after the rebuttal reports were due on the 10th. But if that's not the case, it still stands as I framed the motion to recommend granting OCD's motion in ordering Empire to produce Dr. Lindsay in a timely manner at the request of OCD, with further instruction that his facts and opinions held are subject to discovery.
Okay. Thank you, Mr. Rubin. Appreciate it. So do we have a motion for to grant this?
Mr. Chair, I so move.
I second.
Okay. So now we need a roll call. If we could, Commissioner Bloom.
Approved.
Commissioner Bloom.
Approve.
And I, as the chair, also approve. So we'll pass this through and we go from there. This particular issue is now done. We can move on. Mr. Rankin, you had some other issues that you wanted to bring up.
Thank you, Mr. Chair. Commissioners, may it please the commission, good morning. There are two additional pending pre-hearing matters that I believe the commission should address in advance of the opening arguments on the 20th. One is a motion to compel that Goodnight filed on the deadline, seeking discovery of additional documents from Empire. Empire's filed a response. So that motion is currently ready for decision. Happy to have a separate conference with Mr. Rubin or with the commission as deemed necessary, appropriate to address any arguments or address any questions. I understand it hasn't been noticed for today's agenda, but there is an outstanding request for discovery that I believe is justified and that Empire should be required to produce the documents and be ordered to compel production. So that's number one. The second item is a motion to strike Empire's disclosure of its rebuttal witnesses disclosure. Now, there was an issue that I raised, and I did so as soon as I possibly could, because I am concerned about creating appellate issues. The issue in that motion to strike is that in its disclosure, Empire has identified two additional witnesses, which is fine. They're perfectly welcome to bring in two additional witnesses that haven't previously been disclosed for purposes of rebuttal. However, the two witnesses that they have identified, the subject matter of their testimony is subject matter that was required to be presented as part of their case in chief. And that is testimony around petrophysics, identification of the oil saturations within the target zone, and then also oil in place calculations. That was part of their original direct testimony. And so now, as I sought to confer with Empire Counsel over the nature of that rebuttal testimony, it appeared, based on the disclosure on its face, that it was intended to be a new petrophysical model and a new oil in place analysis. It's not, Empire has not refuted that contention, that in fact, it is a new model and a new oil in place calculation. Based on that, I believe it is improper rebuttal testimony because it should have been part of their direct case. And if it were, then we would have had a chance to ourselves rebut it. Now, if it's new, it's being presented at the very cusp of the hearing, and we won't have a chance to review or analyze it when it was required to be part of their direct case. So that, I believe, is an important issue. I brought it up to the commission's attention through a motion as quickly as I could. Empire has responded to it. We filed a reply brief yesterday, and I believe my hope was that we would get direction on that motion in advance of submitting the written rebuttal testimony so that the issue could be resolved and Empire and Goodnight would have a determination or direction from the commission on whether or not the proposed rebuttal testimony is proper or not. But so I raise that here just for the purposes, it may be too late, but it may not be if we get direction from the commission on what is proper rebuttal testimony. So sort of along the same lines as Mr. Miranda stated, all this testimony is going to be filed on the 10th. There's a procedure in the pre-hearing order for parties to object to testimony. I can pursue that at that time. I can pursue my objections once I see the rebuttal testimony and determine whether or not it is a new petrophysical analysis and a new oil in place analysis. So I raise that just for the commission's awareness. My intent was to try to avoid having to do that. That if we could identify this issue on the front end, that we could address it and have it be resolved without having to wait for the rebuttal testimony to be filed. So I raise that for the commission's interest here on the front end. Those are the two items.
Mr. Chair, members of the commission,
Yes.
I think I can shed some insight on what Mr. Rankin has just said. And part of this just is a function of how many things I could look at. We got the response on the motion to compel Friday after 5. But if it is a motion to compel that seeks discovery, it is certainly a good point that Mr. Rankin is making that, again, discovery denied before, granted on the cusp of a hearing is fairly useless. So the other constraint, of course, is how do we get the commission to meet to decide that motion? It does get clunky, but we will, I think the commission can consider it might serve the party's interest to have that motion dealt with prior to the 20th as well. I don't see how the commission can delegate this to the chair, as the commission must hear the case. I don't know if the parties have a position on that. I suppose if they all agree that the chair could hear the motion to compel, and we can, and in consultation with myself, we could decide that fairly expediently. The other motion, the motion to strike, I respectfully disagree with Mr. Rankin that those types of issues cannot be sorted out at the cusp or during the hearing as to what's rebuttal, what's case in chief. That usually sorts out pretty well once the hearing gets going. So that is something for the commission to consider. The first one, however, compelling discovery. Thank you.
Questions from the commissioners?
May I respond?
Oh, I'm sorry, Ms. Shaheen. Yes, please. I apologize.
Thank you. As Mr. Rubin pointed out, we filed our response to the motion to compel late on Friday. And I think after midnight last night, Mr. Rankin filed his reply in support of his motion to strike the rebuttal testimony. So I agree with Mr. Rubin that the latter is definitely not ripe for discussion today. There are some other issues relating to that I believe Goodnight has a misguided interpretation of the burden of proof. We will be filing a motion to clarify the scope of the decision and including the burden of proof. I'm happy to discuss that if we need to today. But like I said, I agree with Mr. Rubin that is better left to another day. With respect to the motion to compel, I'd like to be able to argue if you're planning to decide that today. I'd like to at least run through our response to the motion to compel. And I'm happy to do that if you're interested in deciding that issue today.
Thank you, Ms. Shaheen. Appreciate it. I just wanted to see now any questions from the commissioners.
Not at this time, Mr. Chair.
Dr. Mpoma?
So, Mr. Chair, we do not have the documents as of now.
That's what I was going to say. I'm not prepared for it. I'm looking through the case files right now online and I can't find it, but it's also, I'm up here, the light's on me, and technology doesn't necessarily work in my favor some days. I personally am not ready to be able to even discuss this right at the moment. So, Mr. Rubin, I'm not quite sure how we proceed from here. I agree with Commissioner Mpoma. I don't have the documents. And excuse me, if Mr. Rankin submitted it after midnight last night, kudos to you, Mr. Rankin, that you were awake that late. I was not. So I definitely have not had the ability to review any of that documentation. So I don't think I'm ready to. I can only speak for myself. I think, Dr. Mpoma, you're on the same page. You're not ready. Commissioner Bloom?
Yes, Mr. Chair, I was wondering how we're going to get at that. If we could have the documents, we might have time to review it. Perhaps we could pause, have time to read those and reconvene in an hour or something like that. But perhaps Mr. Rubin has more guidance.
Thank you, Commissioner Bloom. Mr. Chair, yeah, I think we can huddle. I can huddle with Jim Rosados, and if we need to have another pre-hearing meeting so that the parties can argue. Again, I do feel like the motion to compel is probably of more exigency than the motion to strike, but I'm not prepared to offer intelligent advice on either motion this morning.
I mean, I think for expediency on one of the topics, we could potentially just kind of take a break and discuss amongst us and go from there and get a copy of the information. Again, I apologize. This one kind of got me off track.
Thank you, Mr. Chair. I just want to say I totally understand. This case has been fast and furious and more paper flying, I think, than the commission is accustomed to on a very wide variety of issues. So I appreciate the attention from the commission. As to the motion to compel, I think it's I believe that the regulations govern and it would allow the commission chair to dispose of that issue without the full commission. But I leave that to the commission's discretion and Mr. Rubin's advice. As to the motion to strike, I think, again, given the timing, I think we're all probably better served in terms of where things are to just address it at the submission of the testimony. But I did want to raise that because I think it's an important issue. And we can address it on the 10th, after the 10th in the course of the pre-hearing order. My attempt was simply to raise this issue and try to get it resolved and get direction in advance of the hearing for the benefit of the parties in the commission.
Thank you, Mr. Rankin. Mr. Rubin, were you able to hear all of that?
Yes, I was trying to track down the agenda for today. Was the agenda specific to just this one motion?
Matter to be heard, resolution of Oil Conservation Division's motion to compel expert witness testimony of Robert Lindsay. So that it was today's was pretty succinct that it was going to be expert witness to the motion regarding Dr. Lindsay.
Yes, so the Open Meetings Act has imposed upon us that limitation today.
Okay, so then I think we will table this until after the 10th where everybody submits. And then thank you for bringing up your concerns. And I think we can look at it as of next week when everything gets submitted. And I think at this point, I speak for the commission, we're not ready, if I understand correctly from all of us, to be able to tackle this today. So we will set it for another time. Excellent. Anything else?
Mr. Chair,
Ms. Hardy.
I had one procedural question with
Okay.
respect to the hearing. And our pre-hearing order states that opening statements and argument on motions will be heard on February 20th and the evidence will commence on the 24th. And the commission's meeting notice that came out recently states that the hearing will be held the 20th through the 28th. So we were just trying to get clarification for purposes of our witnesses and our plan that it is correct according to the pre-hearing order that we will commence with the evidence on the 24th and not prior to that time.
Trust me, we don't want to stay longer than we have to either. I think because Thursday, the 20th also has other agenda items, I think that's why it was spilling over into Friday, the 21st, just to cover us on that aspect. I think we are on track just as you have understood it. I think it's just because there are other agenda items on the OCC hearing that need to be heard on the 20th, Thursday, and hence it would potentially spill opening statements for this case into the 21st. I don't think we necessarily expect witnesses to be here on the 21st. I think the case will start its normal track on that following Monday, but it gives the commission the ability to hear all the cases that are on the docket for that particular day.
Understood. Thank you. We just wanted to make sure that we were proceeding according to the plan.
I think we're all on the same page.
Thank you.
Thank you. Commissioner Bloom. Question?
I think I'm on the same page, but just to make sure. So there could be openings on the Thursday the 20th or Friday the 21st, depending on when we get to them. And then the witnesses will start to appear on Monday, the 24th.
Right.
We're all on the same page.
Yes, I believe that's how we all understand it.
Okay, thank you.
And everybody's nodding their heads yes. So that's where we're on with that. Mr. Padilla, you have a question.
Yes, we've discussed whether or not it'd be appropriate to have like a 15-minute introduction for each expert witness. In other words, I've been in cases before the division where we've submitted the testimony ahead of time, but we were allowed to present about 15-minute summary of what their testimony would be. And I think it might be helpful to the commission to have that. I'd just throw that out there.
So I would probably say yes, and I think that is a good idea. Let's tackle that one on the 20th when we convene. I don't necessarily see a problem with that, but again, there's a lot with this case. And so I just want to make sure that we're all treading very, very carefully with how this goes. Commissioner Bloom.
Mr. Chair, I believe we set the PFAS rulemaking up in a similar fashion and found after we got a little bit into that, it was actually very helpful to have people give a short summary of their positions and their testimony at the beginning, just because there are so many documents and so much material to grapple with that by the time we get up here, it can be, a challenge to keep all those things straight. So I think given things we've looked at in the past, it was helpful to have just something that kind of prepares the groundwork for us as we move forward.
Okay. Commissioner Mpoma?
Nothing from my side.
Okay. Mr. Rubin?
Sorry, no, nothing further, Mr. Chair.
Okay. Sure, we'll do it. Since the other commissioners feel the same way, I mean, I'm fine with it either way. As I said, I tend to lean towards that. I just wasn't ready to tackle that one as well today, but okay, that's fine. We can definitely do it.
Thank you.
Thank you. Any other points for this particular case? Thank you all for your patience. Let's take a 10-minute break so then we can start our next case. Thank you. We will reconvene at 10:06. Can you hear me, Sheila? Okay, just making sure that my microphone's working. We're going to get back on record here. Our next item for today is case number 24912, which is the application of Apache Corporation for an adjudicatory hearing to contest the division's conditions of approval on Apache Corporation's scope of work for additional investigation in Lee County. The matter to be heard is the OCC deliberations. Mr. Rubin,
Yes.
Can we get your opinion from here, please?
Sure. The first question is whether the commission wishes to reconvene in closed session pursuant to the adjudicatory exception under the Open Meetings Act.
Okay, commissioners?
Or
Yes. I want a closed session.
Okay, Commissioner Bloom?
I'm fine with a closed session as well, Mr. Chair.
Okay, I would like a closed session as well. So how do we proceed from here, Mr. Rubin?
thank you, Mr. Chair. If the commission can entertain a motion to enter into closed session to deliberate on the adjudicatory matter in case number 24912 pursuant to section 1015(1)(h)(1) and 3.
Okay, can I
I
get a
so moved?
motion?
And I so move.
I second.
Okay, motion
And
is
a roll call?
granted.
We need a roll call vote.
Oh, and a roll call vote, Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
I approve as well.
Do you three want to kick everyone out, or do you want to convene in another room?
So what we could do is we can go upstairs to the OCD conference room and we can connect with you there, Mr. Rubin. Is that okay with you?
Okay. That's great. Let me give you my landline. It's probably going to be a better connection.
Okay. Did you want to just text it to me? Or we can
That's
send you
okay.
we can send you a Teams invite from up there.
No, it's a landline. I don't know how to do that. So let me just give you my number. It's fine.
Okay.
505 466.
Was that a 466?
Yes, sir. 4355.
4355. It's a deal. We will go into closed session here, and we'll give you a call here in a few minutes, Mr. Rubin.
Thank you.
Thank you. Okay, so we're in closed hearings. We will reconvene and we'll let the parties know.
Mr. Chair, are you going to leave the room?
My understanding is that, yeah, the three of you will now convene in the other room.
Or in the room so they could just sit in Pecos Hall. So we'll be giving you a call here soon, Mr. Rubin, from upstairs.
Okay, thank you.
Jerry, what do we do about the court reporter?
That's a good question. We will talk to Mr. Rubin and I will let you know, Sheila.
Okay.
Thank you.
Sheila, good
Yes.
question. We don't need a court reporter in closed session.
Was that a no court reporter?
No court reporter in closed
Okay.
session.
Thank you.